Sarah Boone, the Florida woman accused of locking her lover and luggage and recording him as he pleaded for mercy, has hired and fired more lawyers than most people will meet in their lifetime. Now, the Suitcase Slayer's latest litigator is trying his luck at attorney roulette, but he seems to have bet all his chips on odd. It's a high-stakes legal gamble where everyone's a loser, except the viewers like you. Coming up next, will Boone hit the long shot of a lifetime, or will her only payout be prison? I'm Tiffy Lou, and this is Absolutely Criminal. Now let's dive into the latest court drama with Boone's new legal eagle. Bless his brave little heart. Let's find out if Eagle turns turkey as he attempts to flap his way through a fouled-up fiasco. If you're keeping score at home, and why wouldn't you? Here are the 6 main hurdles that Sarah's team will try to clear today. First on the list, a motion for a statement of particulars. A jaunty James Owen steps up and politely requests the state to clarify exactly what his client did to land her in this courtroom. I mean, we know the basics. Boone's beau ended up dead after an ill-fated game of hide-and-seek. But the defense wants specifics. What precisely was Boone's blunder here? Was it the zipping, the stowing, the lack of ventilation? They're not asking for war and peace, just a little more detail, especially since this isn't your run-of-the-mill whodunit involving bullets or blades. Nope, this is a more unique situation.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with, and the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04 paragraph 2 by an act eminently dangerous to another and evincing a depraved mind regardless of human life did kill Jorge Torres. Judge, that's about as bare bones of an information as you can file in a case. I know any time there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, the victim is dead. 2, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone.
But the state isn't having any of it. The prosecutor is standing firm, insisting that the defense should know exactly what they're up against.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
I have the second citation again, 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendants in 2020.
Both sides have had their say, but of course there's only one opinion that matters. Here comes the judge.
The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
And so, Boone's beginning bid bites the big one. The underdog starts out 0-1. Next on the legal chopping block, Boone's defense team tries their hand at a motion to return property. And in this case, the coveted item in question is Sarah Boone's cell phone. Yes, the same device that recorded her infamous wine-soaked and self-incriminating snippet. Now the defense wants it back. Or at the very least, they want to poke around its digital guts with their very own tech nuts.
Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. But in the alternative, we're asking for an independent exam by the defense.
Response, if any.
As the state has stated in open court while she was pro se, that is absolutely fine.
After a moment of rumination, the robed referee has a ruling.
So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm going to do my best.
The court denies the request to return it, but the defense is allowed to dig through the data with their own dorks. It's a partial win, so let's call it a draw. 0 wins, 1 loss, and 1 tie. Now, let's slide into the next courtroom spectacle, the motions for additional discovery. They want a peek at the rulebook for how interrogations go down at the Orange County Sheriff's Office. Why? Well, they're gearing up to suppress some statements that Boone bellowed, and they're hoping these documents could give them the ammo they need to challenge the whole process. Honestly, this is a bit of a Hail Mary, but it might be their best bet. Will Owens fumble in the end zone?
Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery. Specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation.
But the state is underwhelmed. The real question, they argue, isn't about the sheriff's handbook or what forms they use. So, policies, schmolicies.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th, 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason.
The date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, "I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone?" Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, "Is this where I go to get the phone?" He said, No, we got it back here in this room. Go and come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, "Look, we got the autopsy back from the medical examiner. We've got to talk to you about that." Led Sarah to believe that they're going to talk about the autopsy. In addition, when she starts in the Miranda, judge, she made a mistake on it. I don't know if it's an anonymous mistake. That in her probable cause statement, she said, "I read the rights verbatim." The constitutional Miranda rights, I read to her verbatim. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said, "I read it verbatim," and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay, excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue? I think that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question.
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so. Along
doesn't answer my question. Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that.
And once again, it's time for Kranick to drop the gavel. The decision?
I think State versus Wright is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Denied. No extra discovery for Boone's boosters. The defense will have to work with what they've got, and the loss drops her to 0-2-1. Now, buckle up for the defense's boldest legal gamble yet, the battered spouse syndrome defense. In this case, Boone's defense claimed she had been on the receiving end of some rough treatment from victim Jorge Torres Jr.
Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
The state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, Jorge Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone. But battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
But, of course, the state isn't letting this one slide. They point out that Boone's own statements tell a very different story. One where no violence happened the night her boyfriend suffocated while she slept.
I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. The cornerstone is self-defense. Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them? Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge. I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice, and I would like for Mr. Henderson to respond to what he said about that. But Judge,
because I agree, there's 2 different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue, from the court's perspective, is it applicable?
Ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered? Even
It's premature for them to be arguing the question of intent.
but that's not what Wagner said. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt act
all of
that caused the...
But all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did.
But they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement.
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marcia Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
You remember Dr. Braden said on the issue of imminent threat, Judge, the state doesn't know what happened the 2 minutes prior or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. Fine.
Did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then, like everybody else, we were playing hide and seek. And he got into the suitcase, and I accidentally went to sleep.
If Boone's team wants to go down this road, they'll need to show some solid evidence of self-defense, not just the psychological effects of abuse. As for the final decision, the judge isn't quite ready to deliver a verdict yet.
The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week.
We'll be generous and bestow Boone with the break even on that one. 2 losses, 2 ties, and an ever more conspicuous goose egg in the win column. Will Sarah be shut out? Now let's move on to the defense's request to steady the ship with some expert witnesses. The defense wants 2 experts on board, Dr. Julie Harper, a forensic psychologist, and Dr. Michael Birkland, a crime scene reconstructionist. The state? Well, they're pretty chill about the whole thing, actually. No objection to bringing these experts in, but they do want to see some homework before the trial starts. Specifically, they're asking for written reports from Dr. Harper and Dr. Birkland, presumably so they can prepare to pick apart their findings later. And the judge? Well, he's in a giving mood.
I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024.
Both experts are approved, and the defense gets to keep their dream team. Boone's side books a dub at long last. 1, 2, and 2. Now let's tackle the defense's favorite pastime, asking for more time. Here's Owens as he orates once more.
Last is the defendant's motion for enlargement of time, filed September 17th. Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
As you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move, so we need more time. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request.
But the state isn't buying it. They're giving a hard no to any more delays. According to them, Boone's had over 4 years to formulate a plan, and they're tired of waiting. So are we, Boone.
This is the defendant's trial, not Mr. Owens' trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time.
The judge offers a bit of a compromise.
I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th.
Kranick grants a partial extension, but with strict limits. So the defense gets a smidge more time, but the clock is still ticking. Another draw for the defense, and so Sarah's final score, and we're being generous, is 1, 2, and 3-point back. Now it's time to move on from the motions and get down to business. Trial logistics. Jury selection is just over the horizon, with the trial expected to last about 2 weeks. The big date? Mark your calendars for October 7th, 2024. But trust us, do it in pencil.
With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury's sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case. So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state, and I'll turn it over to you, and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. You think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services.
We'll see if Boone's defense can pull a miraculous rabbit from a hat, or if they'll just be left holding the bag.
If we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, that this was an unusual death, asphyxiation over a period of time, and the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental.
Asphyxiation? Maybe it's just, accent?